So yes, today we have the last two maxims of equity, and then your this topic. Your equities course will be over, and after that we will take up registration, and then my part will be over. So the last two maxims are very much related to each other. Okay. And they are important as well, and you must have already studied them in a different context in Transfer of Property Act, I'm guessing. So the first of the last two are is where the equities are equal, the first in time shall prevail. Okay, and Latin it says qui prior est tempore potior est jure. So if the equities are equal, so person A has some with regard to a matter some equity, with regard to the same matter person B has equity, so you have two conflicting cases of equity here. So equity has to find a way out of this situation. So what will be the determinant factor here? That will be the equity that arises prior to the other, okay, shall prevail. Okay, so if there are two equal equities, okay, you have to remember this, that the equities have to be equal. If the equities are unequal, mere prior in time shall not be enough. Okay, so for example, you may have a prior equity, but there may be defects in that equity, and then you have a subsequent equity that's like proper equity, then this rule may not apply. Okay, so in determining the outcome, then the judges will exercise their discretion in that instant matter. So that will depend on the degrees to which there is corruption in the prior equity. So yes, essentially what it says is that if there are two equities, okay, two equitable rights that belongs to person A and the other one belongs to person B, which one shall prevail? If the equities are equal, then the one that is created earlier shall prevail. Okay, so when two equitable estates are in contest, the one that is prior in time, okay, will prevail. However, as I told you, it's not merely about the equity. Okay, so these maxims will be subject to other prior maxims that we discussed. Okay, so you have to come to the court of equity with clean hand. Okay, so all those factors have to be there. Okay, but if, so for example, you cannot be negligent about your equitable interest which has been created. So all those other merits have to be there for the application of this of this particular maxim. Okay, so the nature and condition of the creation of equity, as well as surrounding circumstances and the manner in which you have acquired the equitable right, okay, as well as the conduct of the party, as I told you, it's subject to other maxims that we discussed earlier. Only after that this particular maxim will be applied. So if after all that, if the equities are equal, then the rule is that the first in time, the one that was created prior to the other will prevail. Okay, so ultimately if the equities are not equal, if it is corrupted by, for example, fraud, negligence, etc., then of course equities are not equal, then the same maxim is vitiated. So yes, let's start with an example that might give you some understanding of what this maxim essentially is. So you know that a contract for purchase of for sale of a piece of land. Okay, so if I, for example, enter into a contract with someone, okay, A, that I will sell a particular land to the said person, and then subsequently enter into another contract with another person that I will sell the same land to that said person. Okay, in such case you see that both are equitable interests which have arisen, because it's not sell, it's merely contract of sell. Okay, so in such situation both of them have equitable rights as against me, and their rights are conflicting with each other. So which one would prevail? the one which was created prior in time shall prevail. So that's the rule. Okay, so a person, however, okay, I'm going a little ahead of myself here. If between these two, okay, one of them, in addition to having prior legal interest, okay, prior equitable interest, in addition to having equitable interest, if they also had legal interest, then the one having legal interest shall prevail. Okay, that's our next maxim. So that's why I said that I'm going a little ahead of myself. But then these two maxims are interrelated. So it says that follows from this explanation of this maxim that where several successive and conflicting claims upon the same subject matter are wholly equitable and neither is accompanied by legal claim which is held by a third person, neither possesses any special feature or incident which would, according to the settled doctrines of equity, give it a precedence over the other, irrespective of the order of time, the maxim applies and priority of claim is determined by priority of them. So if all other factors are equal, okay, so if the equitable claim is not vitiated by any other factor, okay, be it fraud, negligence, if it is not accompanied by any legal interest, okay, as I was telling you, okay, if those are not the factors, okay, if the equities are equal, the rule of priority of time will apply. Okay, now there are certain there is an exception here. Okay, the exception is what we will also discuss in the next maxim. Okay, it's not exception, it's just a case where along with legal interest one also has equitable along with equitable interest one also has legal interest. Okay, so when does that arise? So for example, I hold a property in trust for B. Okay, so B has beneficial interest. Okay, but to the outside world it's not apparent that I have only limited interest, in the sense that I hold it in trust for B here. Okay, so someone who has no notice, okay, of the fact that my ownership here of the estate, for example, is merely a trust ownership, so it's limited by the beneficial interest. Okay, so to that someone, that is not known. Okay, and he could not have known reasonably, okay, about, he could not have that notice of the fact that the interest here is only limited. Okay, purchases this property, okay, in good faith, not malified. Okay, because if it were malified, that means that he either knew that there is another interest, okay, or he deliberately abstained from knowing that someone else had interest. So the doctrine of notice that you have already studied in Transfer of Property Act. Okay, if that is the case, okay, if someone purchases it in good faith and not malifiedly, okay, and for a valuable consideration, you have to pay the consideration. Okay, so in such situation you see that the other person, okay, who purchases it acquires a legal interest in there. Okay, so he has a legal estate there, but the other person has equitable interest, the beneficiary has beneficial interest holder has equitable interest. What about, so is it a conflict of legal interest versus equitable interest? Not just that, because the person who bought it from the trust owner from me also has an equitable interest. Okay, because he purchased it in good faith. So you see there is equality of equity here. Okay, the equality of equity here. But in such case you might wonder that the first in time will prevail, but that is not the case, because the subsequent purchaser also has a legal estate. Okay, so that's why that would be a good exception from this particular maxim. Okay, so anyway, that comes within the purview of the next maxim that we will discuss. Okay, so an application of this maxim, yes, any confusion? Any confusion? Okay, so I guess you guys have understood. It's quite simple. So if the equities are equal, okay, And not just that, along with that, other factors should not be there. Okay, if the equities are equal, then the first in time shall prevail. Okay, so some examples can be found in your Transfer of Property Act itself. So let's look at section 48. Okay, which is nothing but incorporation of this equitable principle. It talks about priority of rights created by transfer. Okay, priority of rights created by transfer. So where a person purports to create by transfer at different times, okay, there has to be, because priority will be determined by time. So where a person purports to create by transfer at different times rights in or over the same immovable property, and such rights cannot all coexist, okay, cannot all exist or be exercised to their full extent together. Each later created right shall, in the absence of contract or reservation binding in the earlier transferees, be subject to the rights previously created. So this is nothing but the application of the rule of priority as had emerged in the court of equity. So again, it is here, this provision is not talking about equitable interest, okay, because in India we do not have such it's all dealt under the law. So even under the law, if there is priority of interest created, okay, then the prior interest that is created shall prevail. And of course, in case of equity, it's all the more clear, as as would happen in England. Another provision of the Transfer of Property Act also deals with the more or less the same issue. That's section 78 relating to mortgage. So it talks about postponement of prior mortgagee. Okay, so it says that where through the fraud or misrepresentation or gross neglect of prior mortgagee, okay, another person had been induced to advance money on the security of the mortgaged property, the prior mortgagee shall be postponed to the subsequent mortgagee. So here's the same rule. I don't think this needs much explanation here. Okay, so yes, if there are two different interests which are created, then the prior one will prevail. Okay, so yes, that's essentially the rule. I hope it is clear. Is this maxim clear? Is this maxim clear?
Yes, sir.
Okay, so let's take the last maxim then, and with that that will be the end of discussion for this topic, for this part of the syllabus. So the next maxim, as I told you guys, is very much related with the first maxim. Okay, so the next maxim is where there is equal equity. Again, the question is of that of equal equity. Where there is equal equity, the law shall prevail. Okay, so again the same rule applies here. There has to be equality of equity. Okay, there cannot be inequality of equity. Okay, the equities have to be equal. So it cannot be vitiated by fraud, misrepresentation, or gross neglect, etc., etc. Okay, the equities have to be equal. So if the equities are equal, okay, then the second part applies. Okay, then the law shall prevail. Okay, so that means if I hold equitable right and you hold equitable right as well with respect to the same matter, but you, along with the equitable right, also possess legal right with respect to the matter, then yours will prevail. It basically follows another maxim, if you remember: equity follows the law. Okay, equity will not go against the law. But if equity and law are like directly in conflict, then you know what the outcome is. Then you go back to that Hofeldian discourse we had. So yes, it says that when A, B, C all have equitable interest, but for example A along with the equitable interest also has legal interest, okay, then of course A's interest will prevail. Okay, thus example have been given: if A enters into a contract for the sale of his house, okay, no sorry I think when A, having title to land, contrives by means of fraudulent concealment to get money from XYZ, okay, the security of the land the security of the land and then disappears, the land is insufficient to pay all of them, XYZ are now left to dispute among themselves as to the order in which they are to be paid. So, the situation may arise that, I, for example, I own a certain land, land, okay, and I use that as a security to, get money from A, B, C, or XYZ, as is the case here, and then I disappear. My property is there. Now XYZ has to fight out because among themselves as to who gets what, okay. But if among these three, okay, if these were all three, equitable estate, but among them if one also had, legal interest, and of course the legal interests shall prevail. That's essentially the rule, okay. So yes, that's why it says that if one has along with equitable claim also legal claim, the one who has legal claim shall prevail. So a case has been case you guys can note down. It's by the name Thorndike versus Hunt. Okay, I will send the name here. Thorndike versus Hunt. Okay, I'm quoting it. Says if the defendant has a claim to passive protection of a court equal to the claim which the plaintiff has to call for the active protection of the court, he who has the legal protection will prevail. So this is just a different way of saying the same thing that we have been saying. Okay, so now application of this maxim is the exception that we had discussed earlier. Okay, so best case scenario would be a purchaser for value, for a value or valuable consideration who has no notice of the prior equitable interest. Okay, so that's the case of application of this maxim. So what is that? So suppose this example that we took. So for example, X and Y had equitable interest, but Z along with the equitable interest also had legal interest. So for example, what happens is that X and Y had the equitable interest, but Z, who had no notice of the prior equitable interest, okay, and could not have exercising his reasonable diligence, could have found out basically the doctrine of constructive notice. Okay, if that doesn't apply, okay, if there was no mala fide intention, okay, if there was no gross negligence or fraud, okay, and acquires an interest for a valuable consideration, okay, then in such case Z doesn't merely have equitable interest, okay, and it is not vitiated by fraud, negligence, so he has equitable interest equal to the other two, but Z also possesses a legal interest, so Z's interest will prevail over that of the others. So that's the application of this maxim. Okay, so if the equities are equal, the one who has along with the equitable interest also legal interest shall prevail, and the application is to the case of a bona fide purchaser. So bona fide purchaser along with because he's bona fide, so he has equitable interest, but he's also a purchaser under the law, so has legal interest, so his interest shall prevail over that of those who have merely equitable interest. So that's it. That's the last maxim from here.